Welcome, everyone. We are live with another episode of Level Up Law, where every Tuesday at noon, South Carolina Legal Services levels up your legal knowledge about an area of law that we practice in. I'm Susan Ingalls, Senior Staff Attorney. I'm here with our producer, Kenneth Elliott, and you are viewing live Attorney Taylor Ott in our Orangeburg office. Today, Taylor will be sharing some perspective on property issues that come up for us here at Legal Services for our clients. And so she'll be talking about you don't really own that property and giving you some thoughts on common misconceptions about land ownership that we run into. But before we get started, we do want you to know that this is not legal advice. It's just general information for the public. If you need the help of a lawyer or you have legal questions, you can always call our intake line here at Legal Services or apply online, and that information will be provided at the end of the presentation today. And just so you don't worry about taking notes during the webcast, we will post the episode, as we do all Level Up Law episodes, on our YouTube channel. And Kenneth is very fast with that and usually gets it done within 24 to 48 hours, so you can be looking for that. Also, the audience will be in listen-only mode, but if you do have a question about anything, you'll see that there is a question box, and we'll be watching that. So we'll try to answer any of your questions, but again, we can't comment on particular legal matters that you might be involved in right now. Also, just want to remind you to be sure to check out our social media. We are on Facebook, Twitter, Instagram, LinkedIn, and of course YouTube, where we post all of these Level Up Law episodes. So be sure to check that out. And all of that information about our resources and how to reach out to us will be on the final slide that we show today. So that's enough about all of that. Now we're going to turn it over to Attorney Taylor Ott in Orangeburg for You Don't Really Own That Property. Take it away, Taylor.
All right. So like Susie said, my name is Taylor Ott. I'm a staff attorney in the Orangeburg office. And today's presentation came out based on a conversation that she and I had a couple of weeks ago where, you know, as an attorney dealing with similar cases and similar clients over a period of time, sometimes you wish that you could record yourself talking about similar issues and an explanation of what the law is, not necessarily the analysis and applying it to a client's particular facts, but what's the summary or an explanation you wish you could just record and have people listen to. And so with the area of law that I practice in, which is primarily marital litigation and probate administration, property ownership is really, really important. And the two things that I find often is people either know exactly what they owned during the marriage and what now needs to be divided, or what they owned, what the person owned while they died. Sorry, when they died as part of the estate and needs to be passed on to the heirs. They either know and have all the documents and ducks in a row, or it's the opposite end of the spectrum and they don't really know anything at all. So I've got to ask questions up front to figure out what type of ownership they might have. And usually there are some situations where people may believe they have ownership of property and they really don't. So that's why we're talking about these common misconceptions today. So the first thing to think about is, when does it really matter whether or not you own property? Again, this is just particular to the areas of law that I practice in, which is primarily probate and family court. Obviously, if someone is dealing with a mortgage on a property or a foreclosure or arguing about who owns the property, you may see different issues come up. But in my practice, ownership of property really matters when we get into a married couple and they're separating. One of the things the court can do, either as part of a divorce action or something else in family court, can divide those assets between the married couple. So it matters either in a divorce action or what we call separate support and maintenance, real similar to a divorce action, but there aren't grounds yet for a divorce. And it's that part about division of marital property. So there's a whole area of law with marital litigation about what's marital and personal property, But obviously, we need to divide anything that the court would consider marital so that at the end of a divorce case, somebody actually owns the property free and clear and can do what they want with it and isn't tied to their spouse having an interest in that property once we're done with the divorce. And then with estate administration, at the point of your death, depending on how you may own a piece of property, that ownership interest may transfer with or without having to go into probate court and administer an estate. So the first thing that I do when I sit down with the family or loved ones of somebody that's passed is we identify the assets of the estate. And that question, kind of like it is with family court, where it's marital versus non-marital, with probate, it's estate versus non-estate. Is it something that really was in that person's name at the time of their death, so therefore needs to go through probate court to transfer the interest to their heirs? Or is it something that person did not own at the time of their death? And then it also is important for us to know what that person owned at their time of death to determine what type of estate we'll file. There is small estate administration, so if the total value of the assets are $25,000 or less and there's no real estate involved, that process is pretty short, relatively cheap in comparison to full estate administration, which is required to pass ownership of real property. So it also matters whether or not you actually have a valid ownership of land, just simply for your use of the property. So with probate court, you have to administer an estate for someone within 10 years of the date of death. Otherwise, it becomes what we call heir property and then has to go through a special process to clear the title. And so you may be within a time frame to fix the issue that exists. So if we identify that you have an estate asset that needs to go through probate court, or within that 10-year time frame, it may be much easier to fix and much less expensive than it is if it goes beyond that 10 years. And also, if you are in a circumstance where you are paying for either making literal property payments, like on a mortgage or a contract for deed, or you are paying property taxes and other things for the upkeep of the property, you may be doing that to benefit someone else that will end up with ownership of the property if you don't actually have proper ownership. When you are doing your own estate and retirement planning, it's important to know what you own and that you are not expecting to have equity in a piece of property or the benefits associated with owning where you're living as your primary residence when you retire. So you don't want to count on something that may not exist, and then you're not going to get a homestead exemption. We'll talk about that in a little bit, but you're not going to get a homestead exemption or a lower tax rate on a piece of property that you don't actually own. So there are these circumstances I run into all the time as an attorney where people think they own a piece of property, but they don't. So we're going to start talking about those now. One thing would be you're paying you're paying taxes on the property, and I think my images got switched. So I'm going to talk about the one that's in relation to the background image here. You may be paying property taxes on the piece of property, and you may be doing that online, like it talks about here. Maybe doing it in person and going to the assessor's counter and paying for it. Ownership of property is not related to payment of taxes on the property. So simply because you're living somewhere and paying property taxes does not mean that you have any ownership interest in the land at all. In fact, I could go to our county government office and pay property taxes for anybody that lives in the county. The assessor just needs to know who to make out the payment to, but they don't care that you're making property taxes on behalf of somebody else. And if that land is not actually owned by you, then paying the property taxes for the piece of property benefits the person who really does own it. And there is the necessity that property taxes get paid within a certain period of time. Obviously, if the tax bill comes out and it's not paid with the fees by a certain date really early in the year, the delinquent tax office will start sending out notices with additional fees. And eventually the property, if it goes up for a tax sale, may end up being sold by someone else. you may have, so this is again, the images are switched. You may have an agreement among family members about who's going to use the property, who's going to live there. So let's say it's a piece of property that's been in the family, maybe sold back and forth or properly deeded at some point from one party to another. You may have a current agreement on who is going to live on the property and make use of it, but that has nothing to do with actually who owns the property. And that agreement among the heirs of the person who last had their name on a deed, or among siblings of which one would live there, it might be relevant as far as establishing some type of right to evict somebody else from the property. But really, it doesn't mean anything at all unless it's part of some type of court proceeding and can be enforceable with a court order. Otherwise, that's really not worth the paper that it may be written down on. One common thing that we run into is that the person who is living on the property, and that may be the client who comes in and they say, been living here for 20 years. I took care of my mom before she died. This was her house, and nobody else has been allowed in the property. And I've posted no trespass notices on the property, and I'm preventing anybody else from using it. Well, that is what an owner does with a piece of property. So you're acting as an owner, you're acting as somebody who is preventing others from having use of the property, but that's not valid ownership of the property. And especially if you have lived in that house for an extensive period of time, and other people may assume you own it because you've allowed or prevented them from coming on the property. There may be this belief in that local community that you actually own the property. Again, that doesn't matter. It may be that you are living in a piece of property where you believe the landowner left it to you in their will. That doesn't matter either. Until a will is filed with the probate court, which can only be done after someone's death, and until the estate is closed and the assets have been distributed to the heirs, including that piece of real estate the person owned at their death, until that's happened, you don't actually have an interest in the property if you're named as an heir in the will. And so with this, the other problem that happens is you may have seen a copy of a will, you may have had a conversation with that loved one or that relative about what their estate plans were, but with a probate court is presented with more than one original and properly signed and drafted will, they will end up going with the one that's closest in time to that person's death. So it could be at the time that you were living with your mom 15 years ago and helping care for her at the end of her life, and she drafted a will, maybe even signed it, that you saw, that leaves the property to you. That doesn't mean that prior to her death, she didn't either make a change to that will or a completely new estate plan that resulted in a new proper will closer in time to death that the court will follow. And agreements, going back to the idea of agreements among family, it may be that there was a family understanding among the siblings or cousins or whomever of what would happen with the land when somebody finally died. That agreement is also has no binding on probate court unless, as part of the estate, the people who would inherit an interest in the house come up with some agreement among themselves. Only then does the family agreement, if approved by the probate court, become something closer to a court order or a settlement agreement that the court would enforce. Frequently, we'll see people who come to us and they say, well, I've lived in the house, usually it's they lived with the person who last owned the house or was last making use of the house, maybe caring for them at the end of life. And they come to us and they say, well, so-and-so died maybe a long time ago. And since then, I've been living on the property, paying all the bills. The utility bills are in my name and I'm paying those. I've paid the taxes, I'm maintaining the property, I'm cutting the lawn, I'm making sure I paid for a new roof on the property. None of that has anything to do with home ownership. That is something that you have voluntarily taken on as someone who's been given the ability to stay in a property. And obviously those are things that are helpful to make sure that the property stays in proper repair and condition so that somebody eventually can own it and make use of it. But simply because you're living in a property and are investing time and money and what we would call sweat equity into the property, it doesn't mean that you have any type of ownership. And then living in a piece of property during the course of marriage does not necessarily mean that you have an interest in that house. One of the first things that we talk about with marital litigation is we talk about, well, who actually owns the home? When was it purchased? How was it purchased? And there are over a dozen factors that a judge would consider in a divorce or a separate support and maintenance action to determine whether or not this is marital property. And frequently there's more than one of these misunderstandings about ownership of property that's happening at the time that we have marital litigation. So it could be that my client is coming to me and saying, well, we lived in that house during our marriage and I helped take care of it and paid for the upkeep. And I believe that it's in my husband's name because it belonged to his mother, and we lived with her and took care of her before she died. And there's a number of different misconceptions there. One, living in the house during the course of the marriage does not necessarily mean that it's marital property that you have an interest in. And just because you believe that the property was transferred to your spouse simply because you were living in the house with someone who may have owned the property, that's that other issue of just because you live there and you've been helping take care of it doesn't necessarily mean that you have ownership. And one of the other things would be, you may be aware of the delinquent tax office and the way that the tax sales work. And with what happens is, after a certain period of time, if taxes go unpaid on a piece of property, there are delinquent notices that will go out to whatever the best address that the delinquent tax assessor's office delinquent tax office has for the owner of the property. And then they will eventually post a physical notice on the property, and the property goes up for tax sale. At the tax sale, it's a bid, it's a public auction. Whoever has the winning bid secures basically a bond on the property. The tax sale deed is not issued until a year from the date of the tax sale. Usually tax sales are going to be November or December of each year, usually at the county courthouse. It depends county by county. Notices of what pieces of property are going to be sold are also published in the paper prior to the tax sale. So the owner of the property, and certainly the person living in the property, when they see, it's usually a neon, fluorescent, large 8x10 sign about the delinquent tax sale, will have some notice that the property taxes have not been paid. And so if you have the winning bid at a tax sale, what happens is you don't actually have ownership of it until a year after the date of the tax sale, when the delinquent tax office will issue a tax sale deed. And usually that actually happens in frequently like March or April, of about 15 months after the actual tax sale date is what we see, at least in the area where I practice. So during that year from the date of the tax sale, there's what we call a right of redemption. And so that means that the person who owned the taxes, not necessarily the family, but the person who owned the property, has a right to be able to redeem the property from the tax sale. So basically buy it back from the person who had the winning bid by paying certain fees, the back taxes, and then a portion of whatever the successful bid was. The longer it goes during that right of redemption, the more that person would have to pay out of pocket. So if you're redeeming a property and you pay those back taxes during the tax sale, it doesn't necessarily mean that you have ownership of the property, because it could be that the person who actually owns the property, maybe a relative of yours, it goes back so far that, and that's what the background picture here is supposed to show, is what we call intestate succession. So when somebody dies without a will, or if it's been more than 10 years since their date of death and the will becomes invalid, you, by redeeming it from the tax sale and paying those back taxes, may actually be benefiting a bunch of other people who will also have an interest in the property when it's cleared. And so this is just to show that the value will be divided between heirs. As far as it's a whole presentation I think that we've done once, if not twice before, on heirs property. But it's just to show that paying back taxes to redeem it from a tax sale doesn't actually result in ownership of the property. It just means that it's not going to be transferred to somebody else by the virtue of not paying the back taxes. Again, this is one where the slide where I didn't do a great job with the description of this. Also, buying the property at a tax sale doesn't necessarily mean you have ownership of the property. What I mean here is you may have a piece of family land that goes up for auction at the delinquent tax sale, and you have the winning bid. We've talked about that 1 year period of that 1 year right of redemption. So just because you have the winning bid at the tax sale doesn't mean you will actually end up as the owner of the property until that year redemption passes and that tax sale deed is issued. So those are common issues that we see when people come in thinking that they own property and they may not actually have ownership of property. It's really that they're making use of a piece of property and have the benefits of staying in a house and being able to have, you know, the utility bills in their name and make payments associated with it. And the reason that you're able to do that is because the mortgage company doesn't care who's making the mortgage payments as long as they're getting made. Same thing with the utility company. They don't care who's paying for the electric bill as long as you're actually paying for it. So we also need to discuss what are ways that people actually get ownership of a piece of property. So there's traditional ways of purchasing a piece of property from a private seller. So that might be where you're paying cash for a piece of property or some negotiated price that you've made. And you're not, when I say private seller, I mean you're not using a real estate agent. It's not something where you're going to have to mortgage the property. You may purchase a property from a bank, and that could be as the result of a foreclosure action. So somebody else owns the property, it was mortgaged, the bank forecloses on the mortgage when they stop paying the mortgage for a period of time, and then it's sold by the bank. And that could be what we call a short sale. So that could be while the foreclosure is still going on, or it could be that the bank, and that short sale would be by virtue of a court order, the court allowing them to do that rather than going forward with the foreclosure. It also could be that as a result of the foreclosure action, the bank became the owner of the property and then is just selling it, usually to clear their loss. And then you also could have purchased it in an auction, and that's what we talked about in regard to the delinquent tax sale. It also can be that you purchase property that doesn't sell at a delinquent tax auction. If it doesn't sell, it goes to the forfeited land commission. Every county has one, and then you can purchase it from the forfeited land commission, usually at a significantly reduced rate. You also could have property that's transferred to you from a family member that does have valid ownership and clear title. So if I owned a piece of property that I owned outright, had proper ownership of, I could transfer to any family member or friend, no requirement that it be friend, maybe for less than fair market value. And I may be doing that just by a deed, like, hey, I love you, I'm transferring this property to you, but we're doing it by a deed that's recorded at the Register of Deeds, paying whatever taxes or fees we need to. It also could be that you were inheriting a piece of property from someone who died, whether they left that property to you in the will, or that you're somebody who inherits from them based on the law if they don't have a will, and that estate was properly administered through probate court. There are fun ways that you may come to own property that are uncommon but are worth mentioning. This is, again, the whole area of law. Adverse possession. I think that we spent probably half a semester in law school talking about adverse possession. And this is just where you make use of property in such a way that it does become yours, but it's over a period of time. And usually it could be a whole portion of property, but it may also just be that it's the boundary has changed between two adjacent pieces of property. Like you put your fence 6 feet into your neighbor's yard, you act like it's yours, you think it's yours. It could have been a mistake with the survey. You may end up adversely possessing or coming to own a portion of your neighbor's yard. Those requirements are pretty unusual to own it that way. You could come to own a piece of property by virtue of litigation. So that just means a court case and a judge has ordered that you're supposed to have ownership of the property. So that could be as the result of some type of marital litigation, or what we call a quiet title action or a deed dispute. So when you're selling a piece of property and you're doing it by what we call a general warranty deed, you're stating that you are warranting the validity of the title. So you're saying, I own it, nobody else owns it. I have the right to sell this piece of property to you free and clear of any other claims on the ownership of the property. Nobody else is going to pop up and say that they own it and I've already transferred it to them. One of the things you're paying for when you go through a traditional real estate closing with an attorney is you are usually paying for title search and maybe title insurance, depending on how you're purchasing it. And that's to do a search to make sure that nobody else owns the property. And here, you may have a court case that's between two people that believe that they were deeded or purchased the property from somebody else, and eventually the court will decide which one of them owns it. You may end up owning property by exercising an option in a rent-to-own contract. So that would be something where you have an agreement with the person who owns the property, you're paying rent, and then there's some way for you to exercise the option to purchase the property. And so it could be, hey, these payments I'm making towards you will be considered payments towards the total purchase price of the property rather than rental payments if I do, if I secure financing to pay out the rest of the purchase price that we've agreed on within so much time. Those are usually not a great idea, just from my opinion as an attorney, but they can result in owning a property. And then there's contracts for deed. So that's a contractual agreement between the purchase and the purchaser of the property, the seller of the property, about the terms of when so many payments are made, that at the end of the contract, the deed will be turned over. That's a little bit different than a rent to own. And then we talked about this already, but when an estate is open in probate court, the heirs to the estate can make an agreement among themselves. We call it a family settlement agreement or a private settlement agreement that states, hey, I know so-and-so would receive an interest in the property, and we're all going to agree among ourselves that this person is actually going to receive 100% ownership, or 50, whatever it may be, ownership of the property. So it could be that you actually are not the person who's going to receive an interest in the real estate that the deceased person owned at the time of their death, but the heirs all agree for you to get it. And so then the court will order the personal representative to distribute the interest in real estate via a deed of distribution that recognizes the terms of that agreement. There are also uncommon ways where you may be able to use property like an owner, but don't actually have standing as an owner. One of the easy things that you may have heard of before is a life estate. It's a little bit more complicated than it sounds. You're like, oh, life estate, that sounds great. Has its limitations. It means that you have use and ownership of the property during the term of your natural life. So it's an interesting concept. It used to, my understanding of the history of it is it would be a way to leave use and property after a husband's death to his wife, because for a period of time, women in the history of our country were not allowed to own property. So you allow her to have ownership and possession of the property, and then upon her death, it would revert, or the interest in the property would then go to another person. And so you could live on the property, make use of the property, but you couldn't actually sell it in the way or lease it in the way that a traditional property owner could. Because if you're selling your life estate or renting out your life estate to someone else, it is only for the term of your natural life. So if you are only going to live another 10 years, or that's the expected life expectancy you have, then upon your death, the person who rented the property from you or purchased your life estate no longer owns it. Automatically goes to somebody else, doesn't have to go through court. Usually you're recording something with the Register of Deeds. And so you may be able to make use of the property with some of the benefits we'll talk about in just a minute, but it's different than what we call fee simple or 100% ownership of the property. You may also have use of a property through a living trust or a family trust. So it could be that the land is owned by the trust of a certain family, or literally one that's in your name for your benefit. And you may be able to live on the property Trust may also describe the limitations of use of the property, but you're not actually owning the land. The deed would list the trust as who owned the land. There are significant benefits to home and land ownership. So this is one of the reasons why it's so important at the beginning of marital litigation or probate administration to have a discussion with clients about what do they actually own, because there are a ton of benefits that come with land ownership over and above having a roof over your head and somewhere to live. If you have true and proper ownership of a property, at least for your primary residence, you're going to get a lower tax rate. So you're going to get I think it's the house and up to 10 acres pertinent, which means close to or adjoining that primary residence. You're going to get a 4% versus a 6% tax rate. And it doesn't sound like it's a huge difference, but the way that they calculate property taxes with the millage rate and all the other things, if you ever look at your property tax statement when you get it, it's super confusing how they calculate that number that you're supposed to pay. But the 4% versus 6% tax rate is huge. I think it's actually different than what the percentages would come out to you. So you can only get a 4% tax rate on one piece of property and only up to, I think, that 10 acres that may be close to it. So if you have ownership of a large piece of land, the rest of that may be taxed at a 6% rate. Then there's also ag rates, so non-ag timber, ag, all those are a little bit different, but they're going to be in the 6% category. Another important thing that happens with the benefits of owning your primary residence is the homestead exemption. So the only way that you can, even if you meet some of these qualifications to get a homestead exemption, the first thing we're looking at is what type of ownership do you have? You have to have what we call fee simple, which is just 100% ownership. You're the only one who's on the deed. Nobody else is listed, or you have a life estate. So, to Taylor Ott for the term of her natural life and upon her death to whomever, I would have a life estate. That's the language that is used in the deed. Or be the beneficiary of the trust who owns your primary residence. So homestead exemption, what it does is it exempts the first $50,000 of the tax assessed value of your property or home from taxes. So if the value of your home and the land surrounding your home is less than $50,000 and you meet the qualifications for a homestead exemption, you're not paying any property taxes. And anything above the $50,000 is what would be taxed. So if your home is worth $100,000, and this is the tax assessed value. So if your home is worth $100,000, then only the $50,000, that amount above the $50,000 threshold is going to be taxed. So you'll see a significant reduction in property taxes when a homestead exemption is applied. It's only available on your primary residence, and you have to meet the qualification about the type of ownership you have. You have to be 65 years or older or disabled. And the disabled definition, the law requires basically that it has a doctor's certification attached to it. If you are getting some type of disability benefit payment, so long-term disability, social security disability, and you have a benefit statement, usually they're not going to look, the tax office is not going to look into it too closely. There's an application for the homestead exemption where you are required to provide all of this information. There is also the ability, let's say you buy a piece of property, you're living there as your primary residence, and at the time that you purchase it, it has a 6% tax rate. Usually if you're buying it through an attorney, the attorney will also help you complete what's called an application for reassessment, where you're asking for to a certain extent, retroactively for the lower tax rate. Let's say you forget, there is the ability to go back, usually it's 3 years from the date that you're disputing the taxes, to ask for the lower tax rate. However, if you're buying a piece of property and the taxes come due after you purchase it, if you've lived there for more than six months out of the year, the tax year that you owe the taxes on, you can ask for the homestead exemption or the reassessment for the lower tax rate. However, if you aren't living there as your primary residence, you're not going to get that. So that is a lot about property ownership and the ways that we see people come in with those misconceptions. And I think the big takeaway here from all of this is just to realize that you may be using a piece of property just like anybody else is using a piece of property without restriction, without any problems, and your taxes might not be too high, but you don't actually own the property. And so it's an important point to consider and answer the question of, do I actually own this piece of property? Because if it comes time to do your estate planning, or you are going through some type of litigation involving the ownership of the property, you want to know what's that point at which I need to, either make it more formal, the type of ownership I have of this property. Like, so-and-so said they were willing to give it to me if I paid the taxes. We'll follow up on that agreement to actually get them to sign over the deed to you and record that deed so you have ownership. Whatever circumstance you may be in, as far as why you're living in the property, what are the facts that make you think that you have ownership? Some of those are things that can be addressed without litigation. It could be that the person who owns the property is still alive, willing to transfer it to you. It could be that it is owned by somebody who's willing to create a family trust for giving you the benefit of making use of the property. But you don't want to continue your life and the decisions you make for yourself and your family based on assumptions about property ownership that aren't true. So if it's something where you can follow through with an agreement or anything, even if it may involve litigation, to what we call clear the title or make sure that you have valid ownership of the property, that's something that's going to benefit you. But you have to investigate and really take a clear look at your ownership of the property. And so it may be that you need to consult with an attorney about the ownership of the property that you may have. So this is where we get to the point of the presentation where we talk about the work that we do. So certainly sometimes we'll have clients that come in for that we prepare. We don't do, when I say that we are involved in the preparation of advanced directives or estate planning, I'm not doing any type of financial planning for anybody. We're doing simple wills, durable powers of attorney, that sort of thing. But the most frequent way that I may get involved with following through on, those agreements for somebody to have ownership of property, or where am I learning about those issues? Preparing wills is a frequent way that we come into information from a client about whether or not they actually own that property. And so if it's something that you need additional assistance, or if you need somebody to look at the deed, or if you need to consult with an attorney about it, if you're, if the presentation today has brought up a question in your mind about whether or not you own the property that you're living in and helping take care of, we have a telephone intake service that is Monday through Thursday, 9 a.m. to 6 p.m. The toll-free number is on the screen, and if you complete an application over the phone, we have a process of where people are screened for eligibility and assigned to an attorney. But certainly you also have the ability to complete the application online. We have information and resources for the general public available at the links below. That is a little bit longer than I anticipated going. Again, it's one of those conversations where the more you talk about it, the more you realize this is information that people don't really have. And I start thinking about issues and points that I'd want to make that are beyond the scope of the presentation today. We are time limited, and I do have to get back to court this afternoon. So Susie, that's really all I've got. I don't know if there are any questions, but I'll stop talking.
Well, Taylor, that was an awesome presentation, and I know that there are so many fact situations that come up, as you so aptly pointed out in this presentation, that have to do with ownership of real property. And maybe for a future Level Up Law episode, you can detail out even more of the things that come to mind along the way. But in the meantime, thanks so much for this excellent presentation on some of these sort of misconceptions about ownership of land and property. It was a great presentation. I'm sure it was really helpful to everyone. And I want to just thank our audience for being here. If you are live with us or if you're watching the recorded version of this on our YouTube channel, we really appreciate you tuning in. And if you found the video helpful, or the webinar, I should say, helpful, and you feel like it might be helpful to others, please do go to our YouTube channel tomorrow at South Carolina Legal Services on YouTube and share this broadcast, because we do want as many people as possible to get this important information, because these are issues that we see coming up all the time when people come in and they really want something else done, but it involves needing to own the property that they're living in. And then we discover that maybe they don't actually own the property that they were living in and thought they did, and that sort of thing. So definitely go share the broadcast. And while you're there on YouTube, please do like the video, subscribe for more, because it's really important to us to have as many people as possible subscribe. You can sign up for those alerts, so every time we post a new video, you'll get an alert about it. And we are knocking on the door of 1,000 subscribers, so you can help us hit that number one of these days. And so also, I do want to remind everybody that we have Level Up Law every Tuesday at noon, and I want you to tune in with us next week for another episode, and we'll be talking about something a little bit related to what Taylor's been talking about, and that is basic probate estate administration. And that's going to be a really, I think, interesting and helpful presentation. We've done some Level Up Law episodes on different parts of probate court and how you go through probate court. This will be just basically estate administration 101. So tune in if you know others that are in the middle of an estate administration, or maybe in the future, or who might just have an interest in this. Definitely tell them to tune in. You can find out about all of the upcoming episodes on our social media, which you see here on your screen. Also, you can just go to our website at sclegal.org and go to the calendar and just click on any Tuesday to see what the subject matter is going to be. So again, thanks everybody for tuning in today on Level Up Law. Taylor, thanks for your great presentation. We appreciate the time that you put into it. And that concludes today's webinar. Thanks everybody.